Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. I'm really churning these things out now because we've got those new contracts, and I'm doing this 2022 new contract changes series. This would be number 4 in the series, and I'm trying to hit on issues that I have seen or questions that I've had related to the new contracts since they bumped over January 1st from the ones you've been using for the last 3 years to the ones that you're now using. And there's a lot of changes to the contract, as you guys know at this point, and a number of areas have expressed some questions or some little bit of confusion in the marketplace, and so I'm trying to hit on those here. I want to point this area out, though, this inclusions changes, or what I'll refer to primarily as solar panels. It references solar panels as an example, and that's really the primary area where I'm thinking that these 2 changes that we've got, and it's not just to paragraph 2. There's 2 changes within paragraph 2, and then there's 2 other changes within paragraph 10 that I want to talk about here today. And they're primarily, again, focused on solar panels. So let's chat about them real quickly here. So what we now have in paragraph 2 when we talk about additional inclusions to the real estate, we call out 2 new categories to discuss: encumbered inclusions and leased items. All right. So again, it's easiest to talk about with specificity as we refer to solar panels. I have seen situations where this might include security systems, as an example, or water softener systems that a house might have purchased, or I should say a homeowner might have purchased or leased or some way financed into a longer term investment. I've also seen it with, I've heard about windows, doors, and sidings purchases where that's done through a long-term amortization or financing mechanism with the window, door, siding provider and the homeowner who gets those things and then puts some financing instrument in place that is encumbered on the property to pay for those things over the course of a period of multiple years. So those could all qualify, but let's talk about solar because I think that's the best example in these 2 areas. When somebody has solar panels on their roof, there's really, I think, 3 ways that they could be there. One is that the homeowner went out and purchased them outright. Less common because they're expensive, right? It's not something that somebody's just willing to write a check for, $30,000, $40,000, $50,000 to have solar put on their house in most cases, but it could happen. The other 2 possible ways is they were financed over a long period of time. Often, 10, 15, even 20 years of an amortization period to bring the monthly cost to the homeowner down very low and maybe approximate something that may look more like a conventional utility bill. And so they often have these very long amortization periods. That would be an encumbered inclusion because it's encumbered with a financing instrument. The other possibility, and some solar panel companies structure their relationship with a homeowner as a lease, a long-term lease that maybe converts to ownership at some period of time, but as opposed to being an outright financing of those or purchase of those through the financing mechanism, they're just leased on a long period or over a long period of time. So those are the 3 ways. If the solar panels are owned by the homeowner, then they're not included in these areas. This would only be in those 2 latter scenarios that I described, which are really probably the most common when it comes to solar at this point in time, and that is they're financed or they're leased. And so it's in those sections, these 2 new areas of the contract, 2.5.4 or 2.5.7, where those items would be called out and described as being either financed or leased, depending on what they are. But here's the important part. There are 2 new reciprocal sections, I'll call them, under paragraph 10, or the due diligence, paragraph 10.6 specifically, the due diligence items. And this is reciprocally to either the leased items or the encumbered items. That is the delivery of those documents. The seller going to be sending pursuant to the deadline in 10.6.1.2 for the leased items or 10.6.1.3 for the encumbered items. They're going to be delivering those documents, either the financing instruments or the financing agreement or the lease document between the homeowner seller and the solar company to the buyer for their review and consideration. But most importantly here, in both of these boxes under paragraph 10.6, for either one, there is a statement that says the buyer will, it's a checkbox, will or will not assume the seller's obligation either under the financing instrument or under the lease. Now, this is pretty important to be paying attention to, and it's important whether you're on the buyer side representing the buyer or the seller side representing the seller. If you're representing a buyer and you're writing an offer on their behalf, you're going to need to understand, or hopefully understand, a little bit more related to what sort of encumbrances are in place, right? How much money is left on that financing? There could be, $15,000, $20,000, $25,000 remaining in financing. And so you're probably, if you don't have additional information at the point of, as a buyer's agent, of writing an offer on behalf of a buyer, in both of those sections, you're going to be checking the box will not, because you don't want your buyer to commit at the time of the offer to assuming the outstanding obligations that a seller has to a solar company, either under a lease or under a financing agreement. So you're probably going to be checking the boxes, or you should be checking the boxes will not, unless you know more at the time that you're writing the offer. Similarly, if you're a listing broker representing a seller and you're receiving an offer from a buyer, you need to be paying attention to those two sections if there's solar or other items, water softening systems, security systems, any of those other kind of things involved, to make sure that whatever the buyer is writing in the offer is consistent with your seller's expectations regarding who's going to pay for this. Because let's assume that it's an encumbered item and the buyer has checked the box will not assume those obligations. What does that mean? It means that the sellers, if they sign that contract, is going to be expected to essentially pay off whatever remaining financing obligation that they have at the time of closing, presumably out of the settlement proceeds. Well, if the seller's expectations were different than that, they're going to be awfully ticked at you as their listing broker for allowing them, or essentially committing them, to allow the buyer not to pay those things off. All right? And so you got to be paying attention on the buy side to those two sections, as well as now the listing side, because there's an affirmative commitment in there one way or the other. The hope with this change is that the discussion related to the solar panels, how they're currently owned, if at all, by the seller, whether they're financed, leased, or owned outright, that discussion gets backed way up in the transaction to the time of contract, rather than what we have seen over the years. And I've heard this on the hotline. I still get calls occasionally from either a listing broker or a buyer's agent who's supposed to close on a transaction in a week or two. They're well under contract. They're through their due diligence. And they call and they say, well, we just found out that the seller doesn't actually own the solar panels. And my response is kind of like, well, how could that not have been something that was discussed much, much earlier in the transaction? Well, with these contract changes, it's going to kind of force, I believe, I hope, an earlier discussion on this. If you're a listing broker and there's solar panels on the roof, when you're going to your listing appointment to have your seller client sign the listing agreement, this needs to be part of that discussion, or maybe even earlier. Do you own them? Do you lease them? Are you financing in them some way? Can we get those documents from you? Can we get those uploaded to the MLS? Can we maybe put some indication in the MLS with regard to what the seller's expectations are of a buyer who's going to be writing an offer? Do they expect the buyer to have reviewed those documents beforehand, and are they expecting them to commit in paragraph 10.6.1 or 10.6.12 or 10.6.13? Are they going to be expecting that the buyer commits at the time of contract that they will assume those obligations? If those are the expectations, you got to get those documents in front of the buyer much, much earlier than what I think our markets have historically done. So be mindful of these changes and little tweaks to the contract. Don't get caught committing your seller to, paying off $25,000 in financing because that's what they contract for, because you weren't having this discussion any earlier with them. So anyhow, hopefully that gives you some insight into those two tweaks in the contract and gives you something to be thinking about. If you have more questions about those or specific questions about those areas, Car Legal Hotline is always available for you. We'd love to hear from you there. And we will see you again on the next edition of Legal Bites, which is going to be another contract, number 5 in our 2022 contract series. So we'll see you on the other side, guys. Thanks so much.